In interpretation of constitutional statutes, we have the doctrine of colourable legislation. In order to understand this colourable legislation, we must have the background of pith and substance, which we have already discussed earlier in the previous video. What does the pith and substance say? It reveals that according to Article 246 of the Indian Constitution, the powers will be distributed between the state and the center. In the state list, the state will make laws. In the center list, the center will make laws, whereas in the concurrent list, both state and center will make laws. That is the procedure, and they should not encroach upon within their boundaries, within their competence, within their jurisdiction. They will have to make laws. They should not encroach upon some other field. That is the thing, the first one. Whereas here in the colourable legislation, the second issue is, see, sometimes they will be making laws encroaching upon the other field belonging to another list. Whereas in the colourable legislation, if the state or center will be making laws with some wrong notion, with some vested interests. See, outwardly, the minute or the details of the law will say like this: says our aim is welfare, development of the society, or upliftment of so and so section, so and so community, or that region, etc., etc. They say number of pretexts outside, but inner motivation is something, some vested interest, some political interests, or some official interests, or some other negative thing, whatever it is. So this is a strategy, or we can say it is a diplomacy. In short, we can say. So if any state or center will make laws with some wrong notion, inside outside very good idea, propagation is very good, but inside the inner motivation and the impact is something negative, then we can say that that kind of legislation is colourable legislation, a diplomatic, a strategic idea of the government. If we study some two cases, two or three cases, we can understand what is this colourable legislation. One important case, Mr. M.R. Balaji versus the state of Mysore. So in this case, very interesting case, the case is related to reservation issue. Here, the government made enacted one act showing that 68% of reservations in medical and engineering colleges. And the second thing is caste-based reservations. Both are quite against the constitution. In the constitution, Article 15(4) of the Indian Constitution clearly says that the reservation should not exceed 50% on the total. That is the first thing. And the second thing is caste basis reservation is not at all the criteria. It should not be considered. The residence or place of residence of the person, the poverty, social and economic backwardness, and all these things must be considered in observing the reservation. So the first 68% is also wrong, and the second one, caste base, is also wrong. But why? When it has come to the court decided it's quite against Article so and so, 15(4) of the Constitution, against Constitution, and even caste basis is not correct. So against Constitution, first thing. The second thing is there is something about motive. See, in pith substance, we have studied that if at all any bottleneck in the provision, as to the provision, suppose the intention, the legislative intention is something good, something sublime, then the court will give the decision in a positive way, at least to some extent, because they study what is the essence, what is the legislative intent, good purpose or not, what is the effect of it, effect of that particular law. All these things will be studied. But here it is not so. When we have studied that as per according to that pith and substance, it is very clear here that they have some vested interests, not development of the particular community or development of students or any region, nothing doing. Some wrong notion, either political interests or some other vested interests, interests of the some administrators, whatsoever it is. Anyway, intention is something bad. It is very clear that the legislation has been colored with some wrong motive, wrong intention, wrong plan, vested interests, etc. It is declared as colorable legislation. Why this? Because only thing is they cannot do anything directly. When the government can't do anything, if they want to make a law according to their own wish, whims and caprice, or according to some their vested interest, they can't do directly. In such circumstances, they can do indirectly. That is the principle behind this colorable legislation. Based on that principle, it will be declared as colorable legislation. So it is a strategy, we can say, a diplomacy, we can say. So let's take another example so that we can have a very clear idea about it. Katie Mopil Noyer versus State of Kerala. It is another interesting case. It is about the property issue here. The petitioner has 25,000 acres of land in the forest where he will be earning very less amount. His annual income will be 3,100 per month or per annum. But the state government formulated one act, that is Travancore Cochin Land Tax Act 1955. There, Section 4 says outwardly, no, our purpose is only to collect the taxes, land taxes. But Section 7 of the same act says something inconsistently that 78 types of land have been exempted. And Section 5A of the act says some confiscation, the hints of confiscation. That means confiscatory in nature. So here, what has happened? The state government imposed, according to Section 4, yes, you have 25,000 acres. For 1 acre, you have to pay 2 rupees. Like that, 25,000 into 2, 50,000. 50,000 rupees as a tax you have to pay. That is the order issued by the state government. And he was taken aback. He went to the court of law, and there it was decided, no, your Section 4 is an apparent one. Apparently, something good, something noble, sublime, everything with good intention. But 7 is inconsistent, and 5.4 very clearly says it is shows that it is confiscatory in nature. So it is quite against Article 14, that is equality, and 19 clause 1A, that is against right to property. And another intention here, the substance of the act very clearly shows some wrong notion inside, some vested interest inside. What is that? Confiscation of the land of that particular petitioner. So that is your purpose. So your legislation has been colored with some wrong notion, wrong idea, a vested interest, or something wrong, not good, and not in accordance with, in conformity with the constitutional provision. So it is called colorable. The court declared that it is a colorable legislation. This is about colorable legislation in brief, so that you can have some idea. Thank you very much.